Well, good afternoon and welcome to today's business surgery. I'm delighted that we're now onto our third surgery and looking at the attendance list, the numbers attending both the live version of the surgery and who are watching it as it's live streamed on YouTube is going up every week, which is great. For those of you who don't know me, my name is Alan Stalker. I am one of the directors of Young and Partners. For those of you who've attended the surgery over the last few weeks, you'll be glad to know that I'm not going to be leading today's discussions. Instead, I'm delighted to be joined by my colleague, Ruth Waters, our managing director. And Ruth is going to be talking about a few things today. She's going to be talking about some of the technical rules that apply to contracts, especially when there's some external event that's happened that maybe makes the contract very different from what everyone imagined it to be. We've got an interview with a really experienced surveyor on issues of construction law, and then we'll have our usual roundtable discussion. So I will, at that point, pass you over to Ruth Waters.
So the topics really today for discussion are words that we've bandied about a lot and clients may be asking you about, or you may indeed be looking at your own contracts and trying to figure out. And the words are frustration, which we may all have been feeling, but it is actually a legal term, and I'll discuss that. And also something called force majeure, which is quite often called the act of God. It probably means more than that, but I'm not quite sure how you define what an act of God is, and good luck to you if you try and do that in too much detail. But anyway, let's start. My starting point for this is always that when I advise are first, before you embark in any sort of potential dispute or situation. And so you should first of all read the contract, as long, detailed and probably boring as that may be, that relate to this type of matter. And we're all thinking about COVID-19 here, and I'll come on and discuss that as well. But look at the particular provisions, get advice at that stage. And that's very important. I don't just say that because I'm a lawyer, and of course I'm going to say that. Most of the clients that I successfully manage through potential disputes are the ones who have spoken to me early and found out where their rights are, where their risks are, and are realistic about what they're going to achieve from any discussion. And then the next stage is to pick up the phone and have that discussion and try and reach agreement. And if you don't reach agreement, you phone whoever else it is that's going to help you out again. And you set out your legal position. But to do that then, I thought it'd be useful to look at what frustration is, what legal frustration is, because actually most of us lawyers don't really know, because, well, the reason for that is because it's hardly been tested recently in the courts. It's a fairly, it's an old concept, it's what's called a common law concept, and the courts interpret it very strictly, and they're very reluctant to say that a contract has been frustrated. So what exactly is frustration of contract? That makes parties' obligations under the contract either impossible to perform or radically different from what the parties contemplated when they entered into the contract. And secondly, the second main issue is that that event and the consequences of it are not the fault of either of the parties. So you need to look at all the facts and circumstances surrounding the contract, and you look at commercial practices at the time and everything that happened when the parties entered into the contract. And then the approach will be, is this event capable as a matter of law of frustrating the contract? And did it, as a matter of fact, frustrate the contract? But it's very, very difficult to establish. And people have tried, and there are cases in the past where people tried basically the argument of, well, that's not what I signed up for. this has now become, because of whatever the event, a lot more difficult for me to perform, or a lot more costly for me to perform. But generally the courts have said, no, I'm sorry, that may well be the case, but nonetheless, really, that should have been within your reasonable contemplation when you entered into the contract, and so it doesn't amount to frustration. I'm afraid you're just going to have to go on with your obligations under the contract. Although usually at that stage, the parties have perhaps put themselves in a position where that's difficult to do, and what you're talking about is claims one against the other for damages because the other hasn't actually performed. So that's what frustration of the contract is. And the way that the commercial contracts deal with that is that they try and provide some certainty. And so a lot of these commercial contracts will have what's called a force majeure clause to cover these sorts of events. And some of these contracts try and define what this supervening event, what this force majeure event might be. And I looked up, I was looking at a sort of fairly standard form, excuse me, I have to get my glasses on here, a fairly standard form of force majeure definition being circumstances arising from any cause beyond a party's reasonable control, including any of the following: act of God, governmental act, we'll come back to that in relation to COVID-19, war, fire, flood, explosion, civil commotion, industrial action, failure in telecommunications services, or unauthorised interference with either party's systems or services via the internet. You can rest assured now that most of these clauses from now onwards will include public health emergency or pandemic or some sort of health crisis type wording. So those are the sort of types of events that are envisaged, and often then in the contract there'll be provision for parties mitigating circumstances in the event of such, or in the likelihood of such, or the circumstance of such an event. So parties can't just say, well, that's happened, so now, you know, I'm stopping everything. It may be that if there are some things that you perform, some services that you can deliver, the courts will say, well, you know, you're bound to mitigate by virtue of your contract. And then some contracts will also provide for a time limit. So if this circumstance goes on for, say, 4 weeks, and you can't perform under the contract for a period of 4 weeks or so, then the contract, you may terminate the contract, neither party terminate, and there's no liability to the other when that happens. But you need to look at your contract to see what the specific provision is there. That's a sort of standard form, if you like. John, I see John Doherty, I see you've just joined us, welcome. Just right at the right time, I'm just about to go into construction clauses now and the force majeure clauses within them, because construction's always at the forefront when it comes to potential issues like these: delay, time, cost, practical difficulties of implementation. Construction contracts by their very nature are complex and difficult to deliver, and there are lots of factors to be taken into account. And that's the reason why in a lot of construction contracts there's provision, for example, for something like fluctuations, so that, you know, if costs go up, there's an allowance for that, and you can potentially claim more where, say, the price of steel goes up dramatically, for example. So in construction contracts, there are many of you come across them on a regular basis. Richard, obviously you do. John, obviously you do. Does anybody else come across these? Robin, clearly the lawyers amongst us know about.
Oh yeah.
Not sure whether anybody else does. Ross, I don't know whether you've got many construction clients in your books that speak to you about you know, auditing or, you know, delivery of contracts.
Only if something goes wrong from on an audit perspective.
Yeah.
implications on that.
Sure, sure. So these standard forms of contracts all make different provisions for force majeure. Most of them don't give a definition of what force majeure is, which I suppose is helpful and unhelpful. Helpful in that by its very nature, it's difficult to define a force majeure, being an unforeseen event. And you can rest assured that whatever you put in the contract as the event is probably not the event that happens. On the other hand, it does mean that there's a lack of certainty. So when you look at your contract, you're trying to come up with the event being a force majeure, that it falls within that ambit, and you need to establish why, in fact, it is a force majeure. So the JCT contracts, they're the standard form of building contract that are used in England and Scotland, slightly adapted in each, but they don't give a definition of force majeure. But what they do say is, if there is a force majeure, then you're entitled to a change of contract, and that might give you time and or money, depending on how you approach that. The NEC contracts also make definitions, but they do make a provision, there's a specific clause 60 for insomniacs amongst us, and that provides that an event, a compensation event, is one that stops the contractor completing the works that neither party could prevent, and an experienced contractor would have judged at the contract date to have such a small chance of occurring that it be unreasonable to have allowed for it, and it's not another listed compensation event. So there you go, there's a sort of mechanical way of trying to work around what the law is, so you can see both the situation there, that event, and the small chance of occurring. There might also be other provisions that you could look at, some of the secondary option clauses that are in there, where there's been a change of the law since the contract was entered into. That might give you scope for looking at whether there's a force majeure, and some other clauses there that relate to delay as well, or inability to get to site. They may kick into play too in the construction sector. In the NEC contracts and in some other commercial contracts, probably more in English contracts, English law contracts, you see, Alan, you might want to comment on this, but in the NEC contracts, there's provision actually for parties acting in the spirit of mutual trust and cooperation. And so parties have actually a contractual obligation to try to work together. John, I see a wry smile there from you. Of course, these are words, and it very much depends on the actions of the parties and what happens when there is a potential dispute, and money and costs start to come into play. But what that does mean is that in situations like now, as I know a lot of contractors and clients have been doing, is discussing the impact of COVID-19, how it might be dealt with, discussing how delays are going to be dealt with, what are the delays that are foreseen, and logging them into early warning registers, for example, and meetings and programs then need to be updated. You also need to be very careful with contracts that you're checking what are your obligations for notice, so that you don't miss timing on that, and you should also be very, very careful of effectively terminating a contract, either on the back of force majeure provision within the contract, or arguing that there's been frustration of contract, because it is very difficult to establish, and the consequences are so severe, because you're effectively saying, I'm not performing anymore, or rather, I can't perform, and so I'm not going to perform anymore. And once you do that, then you're exposed potentially to what could be quite substantial claims for damages. So that's really just a quick general run through of the law, but how does this all apply in the COVID-19 situation? And I guess the first answer to that is, again, back to your contract. You look at what your contract says, look at what the specific terms of your contract provide for, because even with these construction standard form clauses, a lot of them are revised. So you'll find that there might be some additional provisions in there, changed provisions, and you need to take account of them. I think that COVID-19 and the effect of that on contracts and how that's going to affect contractors and clients, there may be a real issue here with potentially the difference between guidance that's been issued by the government and what the regulations actually say. And that may be something that comes out in the next few weeks and months when parties are looking at that, because the regulations have now been set out. We'll probably all know that. They're in the Health Protection Coronavirus Restrictions Scotland Regulations 2020, and they come into force, or are in force now, for a 6-month period, but there's an obligation on the Scottish Government to review them every 21 days and review the restrictions there. But what they've not done is, they've set out sectors, companies, or rather businesses that must close, and these come within parts 1 and 2 of the schedule, and then they've also set out provisions for other businesses that are listed at part 3, but it's not a blanket ban on businesses. And construction industry and the construction sector in particular have had some quite mixed messages from the Scottish Government and the English Government, and the Construction Industry Council, which issued site operational practices, which were then withdrawn just a few hours later after they did that. So there are a lot of issues here to consider. In the face of it, you might think, well, pandemic, really not much I could have done about that, not much that was foreseen about that. But that isn't just a black and white answer to the question as to whether you can say contract frustrated, end of. There may need to be a very careful examination of the regulations and actually what legal obligations there are in businesses in terms of health and safety, clearly, which is paramount in the current situation. But what steps could have been taken by businesses to continue to operate in the current circumstances? One of the exemptions, as we all know, in social distancing is where you leave the house in order to go to work, where it's not reasonably possible for you to carry out those work activities at home. For those of us who are office workers, then we can manage, we can go online, we can access the cloud, we can hold forum like this. But for people who are right at the, right on construction sites or at the cutting edge, it's difficult for them to look at working practices and how you adapt. If you can adapt working practices, how do you run a site safely? What are all the issues? And if you do actually stop, what are all the issues that face you? Like insurance, safety of the site, who's going to pay for that? Lots of questions that will need answered. And again, very careful consideration of what your current obligations, current contractual obligations are. Richard and I had a question and answer session, just a discussion, which I thought we could show as part of this, and then just open it up to everybody really to put forward any thoughts, questions on frustration and force majeure and impact on contracts. So Alan, I wondered if you could just show that brief video that we've got. Well, good afternoon. This is the third of our business surgeries. I'm Ruth Waters, Managing Director of Young & Partners, and today I'm going to be speaking to Richard Neilson of Quantum Solutions Limited. Richard will explain a bit about his business and what he does, but I met Richard back through a group that he set up called Building Banter, which was a very good networking forum down in Kilmarnock. We met on a monthly basis. I think it was the start of the month, Richard.
Yes, early on a Friday morning. Yeah.
That's it. So 8 o'clock till 10 o'clock, and that was a very good forum, and it was certainly very well attended, particularly from people around Kilmarnock, Ayrshire, that maybe weren't serviced by some of the larger city practices and city professionals, if you like. So, Richard, do you want to tell us a little bit about your business, and then we can talk about everything that's happening at the moment and impact in the construction industry and just what you're seeing in practice?
Sure. No, thanks, Ruth. Thanks for inviting me to have a chat today. Yes, my name's Richard Neilson, Director and Owner of Quantum Solutions, which is a quantity surveying and project management business. We deal with a number of different sectors in construction. Two of the bigger ones just now in the last number of years has been the whisky distillery sector, housing, etc., and a number of commercial jobs that we've been involved with. So yeah, we've been trading since 2009, so we're about 11 years set up. We did set up originally at the very start, or just as the recession was taking grip, actually, back in 2009. So it was interesting times then, and certainly extremely challenging times just now. So yeah, we're just trying, like everyone, to understand how best to deal with things at the moment. Such a sudden decision to close the construction sites in Scotland for all the right reasons from the Scottish Government. But it's obviously trying to deal with that just now in the short term impact. And I think very much thinking ahead of what provisions we need to start thinking about when the sites start opening up again, and trying to be a bit innovative in how we approach that. So that's where we're at just now. Yeah.
It's been such a sudden event, really, hasn't it, in terms of what's happened and for the construction sites. And there seems to be a bit of confusion, or a difference, I should say, between Scotland and England.
Yes.
In England, the guidance from the government seems to be less clear, and we were just talking there, Richard, the Construction Leadership Council had issued a second version of their site operational procedures yesterday, I think, which was withdrawn within a couple of hours. And that guidance, or those procedures, indicated that the 2 metre rule was mandatory, if you like, and that if you couldn't maintain 2 metres, then you should not work. Whereas the version 1 previously had really said that it was recognised that it might not always be possible or safe, in fact, for people to maintain that 2 metre distance. Have you got English clients? Are you getting back from down south on that?
Yes, we do. I think it's strange with what we're all dealing with just now. This area seems to be quite a variance between England and Scotland at the moment. I thought, to be honest, when Nicola Sturgeon announced it those few weeks ago, or a week and a half ago, of what was to happen in Scotland, I know England at that time wasn't approaching it the exact same way. I did think it would probably change quite quickly from England to approach it in the same way as Scotland. So there's still a bit of unknown why that's the case. All I can say in Scotland, as soon as that announcement was out, I would say 90% of the contractors that we are working with just now on live sites had notified us the following day to say that they were going to conform with guidelines from Scottish Government. And literally the following day, they were off the site. They were notifying us to say that they were trying to conform with government guidelines. And that they would go on site to make it safe and secure as best they could. They gave us a very brief notification by email, nothing highly contractual, just something in normal language, normal speak, to explain that, we've been told to come off site, we're doing that, we'll make it safe, and we'll keep in contact. So it was very, very quick, for sure, and I think that will have been the same throughout Scotland. Obviously projects that are constructing any building or renovation relating to emergency type buildings, hospital facilities. These projects in Scotland, as far as I'm aware, are still going ahead and being carried out just now. But I think that they are the only ones. Yeah. But no, when you're asking about, we do have a few clients that are based out of England and do projects throughout the UK. And there was a lot of confusion for them at the time because, when we were saying this is what we've been informed in Scotland, as I said at that time, they couldn't really fully grasp it because they were getting told something very different from how to deal with projects in England. So, and I even got correspondence yesterday from one of our clients confirming that it must be difficult because there's such a difference in the approach at the moment, and how we help our clients manage that, I suppose.
Mm-hmm. And what steps are your clients taking from a contractual perspective, or are they taking steps yet, or at the stage of perhaps now starting to look at the contracts and having a think about what they do, because they might have liquidate and ascertain damages clauses, delay, what steps are they taking?
That's very interesting as well, because we get asked from our clients in the last week and a half how we should approach this, and we did a lot of research, not a reasonable amount of research, just to see what was coming out in the industry, what was coming online, and what we took from it very much was, yes, you need to put something in place, but you really need to act ethically, fairly, reasonably. I think if you were to go in a very contractual position, at this stage, it doesn't feel right. It doesn't feel right. The people that have stopped the work have been told to do so very, very quickly from Scottish Government. So what we've advised the clients at the moment is, if we receive any communications, which we have now from all the contractors we're working with, we've advised that we do respond, and just say, look, thanks for letting us know. We appreciate that you're acting in guidance from the Scottish Government, and that you suspended or stopped your works on whatever date. So at least you then have a date somewhere that is confirmed when the work stopped. Mm-hmm. We're then advising them to ensure that the sites are safe and secure, ensure that all their insurance provisions still continue through the shutdown period. And the valuation side, obviously, companies are very focused that they make sure to get the valuations in up to that point on when the works have been suspended from. And that's for contractors to continue working. I think that's a huge important aspect, because it's their workload has disappeared overnight. So we'll be very, very focused on getting paid for, at least get paid for what they're due up to when the works have stopped.
And did you have any experience of going on site quickly to monitor or to measure, what supplies, for example, were on site?
Yes. We were fortunate. We had already done a number of projects the Friday before the announcement came out, and it was at a time when already the digital side, I think that people were already working remotely, and we had kind of adopted, like, well, let's take a video of the site, because some of our clients wanted to speak to us about the progress in the jobs. They were trying to get clarity, and instead of just taking pictures, we were taking video footage and getting a bit more detail. So I think that's very important for any site, that you do have if you haven't at the moment, still go out just now as soon as you can and take a good log of what's been done. And that's not to catch anyone out. It's just to draw a bit of a baseline of where it was at.
Absolutely.
So exactly when it picks back up again.
Yeah. And that's advice I would give to both clients and contractors. Have a recording of the condition of the site and as it is. And as you say, purely from the perspective of just an evidence of what's their situation is. Because for contractors will be looking for a payment, for work that they've done, for deliveries to site, subject to their contract conditions, as at the point when they stopped working. And valuation processes will still continue.
I think the aspect I think everyone will be trying to understand, both in the client and the contractor side, is there's obviously going to be ongoing costs for say, projects when this shutdown is higher costs for scaffold, plant, machinery. What happens if the site, it's been very sudden stops to site, so some of them will be left a bit more exposed than others.
Yep.
There'll be wind, rain, the elements will be getting into some of the buildings. So the costs in relation to all this, I think that's what is going through my mind. When it opens back up again, here's a cost. So both client, contractor, everyone in the sector just now is struggling. We're all less work. We're focusing on our cash flow. So what's the fair way of dealing with that? How is these costs met? Are the government going to step in to create something new that covers that cost so that it doesn't fall at the foot of the client or the contractor? And I don't see these costs necessarily being, massive costs for every individual site, but there is going to be costs. There'll
be ongoing insurance and the costs that you mentioned, security perhaps as well.
Sure. Yeah.
And is there a lobbying force to the government at the moment to step in and to have a look at that? Do you know, Rich?
See, I'm not aware of that. We did, and I don't know if you've seen this, Ruth. We've got a statement from SPCC, from the chair of SPCC last week, the 26th of March. And what was interesting that we've read from that is that it's stated from Lisa Catanach, the chair of the SPCC committee. It basically says, however, as the current pandemic gives rise to new contractual issues not previously experienced before, there are no clear, distinct provisions in the contracts which fully address the issues the industry is facing. So that's one of the only kind of bits of information I've managed to get hold of. And I don't know.
Yeah.
So that statement will be, people may agree or disagree with that, but I think it's hard to latch on to any specific provision just now.
There's a lot of talk about force majeure and frustration of contract, but you need to look very carefully at your specific contract conditions to see what applies, and where you've still got ongoing obligations such as insurance. Force majeure force majeure may apply, frustration wouldn't, because that would effectively that's effectively where the contract is ended.
Yes.
So some of the standard form contracts make provision for force majeure. In fact, the majority of them do make provision, but they don't include definitions of what exactly is force majeure. And there will be a lot for people to consider and work through in these contracts in this particular set of highly unusual, unprecedented circumstances. I was thinking about where you've got, for example, an English supplier or an English contractor, supplier to an English contractor, who may still be operating in site, but in Scotland the sites have been closed. How will that impact on any interpretation that the courts might have of frustration, for example, of the contract? Lots of legal issues there for consideration, but lots of very practical, difficult, immediate considerations for contractors to try to sort out now. And I think in the first instance, discussing what the issues are with the client and trying to reach an agreement on them by far has got to be the preferable option for them than trying to pour through contract conditions at a later stage, though I suspect that will happen.
We haven't seen in this short term any contractors notifying us at the moment there will be costs or there will be we'll approach it in this way. We haven't had that at all, and I think they'll be the same as everyone. They'll be waiting for a bit of direction. You know, they've been told to the government to suspend the work, so they've notified that and they've conformed with that. But the next step of how they should potentially deal with it is something different. I think as well, it's appreciating that when things do obviously start back as well, levels of productivity will be affected. You know, people will still be, some people will come to site, others will still have to work remotely. You know, those that have pre-existing conditions, those who are looking after, you know, children, childcare requirements. So I think that's an interesting one, because we all want to hit the ground running when it opens up again. It gives more productivity, it assists with cash flow, etc. But as soon as we start up, it's a different landscape a little, you know, for another few months after that at least. So I think we all need to think a bit about that just now, because we do want good productivity when it opens up again. But we will have some people go on site, some people will be able to go to the office. There will still be a good percentage working from home. Yeah.
Absolutely, and construction industry is so important to the UK economy, isn't it? 8% of GDP, 10% of employment in the UK, so it's a huge sector, and you know, a lot of issues facing it at the moment. But thank you very much, Richard. That was very helpful, and I hope that you found this useful. Certainly, any issues, please contact us to discuss and go through, but in particular looking at contractual issues and where liabilities and rights and responsibilities lie, then please give us a ring. Thanks very much.
Thanks, Ruth.
So thanks all for watching that, and that was specifically focused on construction, obviously. Does anyone just be general contractual matters that they've been looking at or thinking about in relation to COVID-19?
Yeah, Ruth, if you don't mind,
John,
I'll
fire away.
ask a couple of questions and tell me to stop whenever I've asked too many.
No, you just fire on.
The onus of responsibility, Ruth, in your opinion, with who deems something essential? Okay, the government has put out 13 essential designated activities on sites or on construction projects that they deem essential.
Yeah.
Whose responsibility is then to deem whether that specific site is essential? Would it be, and this is solely from a legal point of view, because if I read, I'm just pulling it up here, if I read their 13 designations, energy, communications, government, transport, finance, etc., right? I'm particularly dealing with energy, right? We're left in a very precarious position where clients are deeming everything or almost everything that we're doing in that sector as essential. Okay, and the guideline states that even where businesses are in the CNI category and judge themselves to be exempt from closure of business premises, it is imperative that they keep open only the premises or parts of the business that are totally critical, right? Now, whose responsibility then is it to deem whether a certain project within that sector is essential? Because we as a company are left in quite a precarious position where certain clients are deeming everything essential and are telling us that you must continue as it's deemed essential. I don't particularly want to give examples because then it would be
sure. No, it's a good question, John, and it's not a straightforward one to answer. I guess you need to look at the regulations first of all. Set out what the legal position is, if you like, in terms of businesses and the operation of businesses. So that they set out the legal issues and then the criminal sanctions if you fail to comply with them. So that's one thing. Then there's the guidance that's come out from the government. What legal effect does that guidance have? Who then, as you say, is going to interpret what that guidance means, and how does this impact on your employees and what your obligations are? I think both parties to the contract probably have to look at that and decide on their interpretation of, well, firstly look at the regulations and then decide whether they can safely operate that site or not. Now, a client may be telling you that it's deemed to be essential, but if you don't deem it to be essential, then you would need to set out your position and say why, and potentially then look at the contract and the provisions within the contract as to whether there has been a force majeure and whether you're taking steps under that contract. But you would have to look at it on an individual basis. It's a very difficult one. There isn't a clear answer to that, but essentially what one party is saying to you is you must perform your contractual obligations, and if you deem that you can't perform your contractual obligations, then you need to look at the contract to see, do you have a contractual provision that says that that covers that type of event? And secondly, what am I going to do about that? Is there a change circumstance? Can there be some sort of suspension which might be provided for in the contract? Is it a termination situation, which of course, as we've just said, is very, pretty draconian, in that if you terminate it and you're wrong, you face substantial claims. So, yeah, a difficult one. I don't know what the other lawyers think. Robin, have you got any thoughts on that?
I had to look at this whole issue for a client last week. There's two levels of information coming out at the moment. On the one hand, we've got the regulations that these have legal force. So those businesses which are listed in the regulations as being required to close, either all or part of their premises, must close. Not to do so is a criminal offence, and that can impact both on the business itself and on the directors, because they can be held personally responsible for any offence committed under the regulations. Separately, what you've got is the Scottish Government guidance that was issued actually much earlier. I think it was 27th of March. Now, that guidance does not have the force of law in respect that it does not create any offence if you don't do it, and it sets out that businesses ought to close except for those which are able to operate with appropriate social distancing in place. But it is not a legal requirement for them to close. John, I think, looking at your particular one, obviously there are different parts of the energy market where one could say it is critical or it's not critical, and I suspect that for that particular,
whose responsibility is it, Robin? Whose responsibility is it to deem whether it's critical or not?
Yours, John.
The point being, of course, that it's nobody's actual responsibility, because these are not requirements of the regulations. This is simply guidance that has been issued by the Scottish Government. So if you've got a client who's saying this is an energy project, therefore it is part of the critical infrastructure network, therefore we're exempt. Yes, they're exempt from the guidance. But to that extent, it is a matter for it probably is a matter for the customer. But
I think the thing is, John, the responsibility ultimately is yours if you get it wrong. And if you look at what the guidance says, it would have to be really, really clearly required as being essential repair or maintenance or operation. So almost certainly what you're doing isn't within that. But the customer is still saying, no, you've got to stick with it.
No, the customer's saying it is essential and it is required. So who am I to say that that piece of their business infrastructure that we're working on isn't required? Because we don't know how all the pieces of the jigsaw fit together. That's my argument. That's what I'm asking advice for, because it leaves us as directors in a very precarious position here. We're sending employees to work. We're putting all the appropriate protocols in place to maintain social distancing where we can. We're actually putting protocols in place insisted upon by our employers where we cannot ensure social distancing to create to carry out certain tasks where people are wearing will be wearing, if we can get it, full PPE, face masks, visors, etc., etc. I believe some of these projects may not be critical, but what is it or essential? What is but who am I to decide whether they're essential? If I said, I'll give an example, a one farm, right? Working on a substation for a one farm, I've been told is essential. Okay, we can all say, well, how can that be essential? If our client is saying it's essential, who are we then to decide it's not?
I think if, for example, Scottish Gas Networks were saying it's essential, I think you just accept that they're the best person to judge that. Yeah. I think it's much more difficult when it's a smaller operator, when you're having to balance what is the risk to my employees against, if we think about what the guidance is saying you're not obliged to close. So it won't necessarily be a criminal offence to continue working in that essential area. It's not a requirement for you to do it. Rather, it says you're not obliged to not do it. So it's one of those sort of odd double negative ones. But I think unfortunately you have to take a really harsh decision internally to say, well, I'm sorry, your tiny, tiny wind farm, maybe it's not as essential as it seems. But then again, as you say, how do you know?
I think,
or at the very least, make inquiry. Have the client say why it is essential, so that you've got some sort of decision-making process there. What information you got, what you looked at, what the factors were that you considered, and why you continued.
I think the essential point is, and I've got the guidance here in front of me, and I think this is the critical point. What the Scottish the guidance that the Scottish Government has issued says, and I quote, "As such, we would advise that all business premises, sites, and attractions not required by law to close should now close." So that is advice. It is not. It is a recognition that those businesses are not required by law. So, if, for example, you have a client who's saying, I'm saying that this is essential, that my premises continue to operate. They're in practical terms, if they're not required by law, they're probably entitled to take that view. It goes on to say that those businesses not required should close unless they are essential to the health and welfare of the country, supporting essential services for wider public health considerations, or some other exceptions. But in practical terms, if you are not required to close, what position would be taken if, for example, you said, well, I'm not coming out to that site to work on it. And if you're contractually obliged to work on that site and the client's not obliged to close the site, it's a difficult question. And I think we won't see any immediate answer to those questions. Could you be criticised for following government advice? Probably not.
Okay. The tack that we have taken regarding critical and non-critical, as we put it back to the clients, right? Because they are large utility organisations we're talking about. They've given us a blanket letter saying all sites are essential. We have now gone back to them and saying, sorry, that doesn't cut it for us. If our personnel are stopped by the police and asked, are you essential? Is it essential that you're travelling? And what essentials are you going to, that we need something to demonstrate that it's just not all your projects that are essential. Obviously, when we ask this, they're not giving that guidance, or they're not giving that specifics. So we're continuing. We have issued under our, I'm glad to hear that, Richard, your contractors seem to be taking a very non-contractual stance on this. We unfortunately have taken a very contractual stance on it, because we're trying to protect our business as well from any damages that may be incurred and any costs that we're currently incurring. We have issued early warnings and compensation events due to the directive to keep social distancing, as we see that as a change to the works information and an instruction by our employers, which will incur additional costs, which has also led to our supply chain disappearing overnight, which in some of our contracts is our responsibility. So my advice to other contractors is, although this is a very emotive issue and people sometimes are taking a very soft approach, I would advise that you cover yourself contractually as quickly as you possibly can, because when the dust settles here and people see the enormity of the damage that has been caused, and I'm talking about the commercial damage, the morals and the thing we should have done will disappear out of people's minds very, very quickly. And you will get damage notices from your employers. We have stayed away from, in the NEC contract, clause 60 regarding force majeure, because most of our clauses have been adapted or modified with Z clauses, which state that, yes, if you can prove a force majeure, it will get you time, but it will not get you any cost.
Get your money.
So what we're trying to do is we're trying to fashion something here that will get us money due to a direction or an instruction which is given. And a change for us is you must keep social distancing. That's a change to the contract. That wasn't there whenever we entered into our contract. So that's the status that they're also putting with all contracts.
Yeah, and potentially that PPE equipment that you're going to supply and so on as well.
And that every man coming or woman coming to work drives in a separate van.
Yeah.
Accommodation that we're dealing with, we quite regularly have shared accommodation. We're not allowed to have shared accommodation now, so we're now sourcing flats for people working in this industry on a single occupancy basis. So all of those costs are being incurred. So we're trying to protect ourselves. Obviously, we don't. All of our sites aren't still working. You know, local authority sites have closed overnight.
Yeah.
But our friends in utilities have not closed at all.
Yeah.
Okay.
Okay. Anyone else want to add anything?
I think just coming to the issue about police stopping people going to sites, John. The bottom line is, if they're going to a site, it's probably something that they can't do from home, I presume.
Yeah.
Now the powers given to the police are only to in relation to people who are unable to do their work. So if so somebody that like us that can sit and work from home doing office work, that's fair enough. Somebody who has to be on site can't do that. So the police powers there are limited. And again, this is, as far as the police powers are concerned, that doesn't bring in this issue of essential services. under the regulations. So again, it's not something I would be overly concerned about. Obviously, you need to maintain appropriate social distancing for your employees, and that the measure that you put in place, travelling in separate vehicles, separate accommodation, all seems to me to be the appropriate steps to take. But in practical terms, I don't think you'll actually find the police, I would hope, stopping every vehicle that's on the road saying, where are you going? Why do you have to be there? I don't think we've got the resources to do that.
That was the issue, wasn't it, with the Derby police, who were out filming people from drones, and I heard what a sort of ex-senior judge really slating that, saying that the police are there to enforce the law, not the government guidance as such. They're there to enforce what's stipulated as a matter of law and what is a criminal offence. So I think they're separate matters, aren't they? Linked, of course, but separate. Okay, anyone else? Gordon, what about you? Have you got any of your clients speaking to you about issues, maybe PR issues that they're dealing with potentially? Is that something that you would cover?
Yeah, I had a long call yesterday with the MD of a window company who operate throughout the UK. Basically, they've closed down. They did furlough all of their staff, but they're looking to bring quite a number of them back, actually, to answer customer inquiries relating to orders, but also to look at doing, because apparently architects and so on are still working, and there's inquiries coming in from them for technical information and so on. So they are looking to bring some of them back, but we have another client who is very involved in construction within hospitals and schools, actually, and they have pretty much stopped, apart from any work that's relative to hospital maintenance. So these are about the only two construction-related clients we have. But at the moment, both closed. But as I say, Nordan looking to bring people back, and this is something we're seeing across every sector. But clients that furloughed everybody right away are now desperate for the 3 weeks to be up to bring them back again, because they just assumed there was going to be no business, but now they're realising there's a lot of business to be had out there. And well, not a lot of business, but there is business to be had. So they're biding the time till the 3 weeks is up till they can take them off furlough. And I don't know why they're bothering, because they haven't registered any furloughed employees yet because the portal's not up and running. But if they're desperate to get them back, I would just be bringing them back. But it's that's a decision they have to make.
Yeah, a lot of businesses facing a lot of difficult issues getting through this time. Does anyone have anything finally that they want to add here? If that's us going for an hour, if anyone's got anything else other than that, just to say thank you to all of you for joining, and we'll be running another business surgery next week. We'll send out details of that, but we're also fluid in that, if there are particular issues that you want to raise, just email us. Things that you would like to talk about at this business surgery. What we're hoping to do is get groups together and get a bit of interaction. So thanks all of you for participating and joining today.
Thank you.
Okay, thanks very much. Thank you.
Bye.